let's get started. My name is Matt Christensen. I am the managing partner here at Hansen Johnson. My practice is business and real estate and bankruptcy. This today is part of a series of classes that the firm has presented. All of them are available on the firm's website. There's a link to media and videos there. This is sort of a continuation of a couple that I've done in the past on the stimulus bills from Congress and the after effects of those, the rules that have come out from the SBA and other developments. There's other presentations that we've done deal with real estate, employment law, tax, family law, those issues, and how each of them are affected by the COVID situation. We do plan on continuing these classes on a fairly regular basis. We most likely will morph from discussing the COVID situation and simply get into some legal issues in some shorter videos as we go forward. Because I am an attorney, the Idaho State Bar requires we give a disclaimer that we're not providing any sort of specific advice about any specific situations that you may have. We're trying to just convey general information about what the current status of some of those things are. So today focuses on the stimulus bills and specifically the loan provisions of those bills. So I will start with just a sort of a short history of the PPP loans, where they came from, what kind of developed afterwards, and then what is still developing. There are still some sort of uncertain issues on those loans. So the original CARES Act was passed back in March. This is the act that authorized the $3.5 billion for loans to small businesses. They became known as the PPP, Payroll Protection Program loans. After the act was passed, then the SBA issued an interim rule for how to administer these loans. Under the terms of that interim rule, the PPP loans were a 2-year term, so repayable in 2 years, 1% interest. The amount of the loan was based on 2.5 months worth of your payroll costs. Under that original rule, you had 8 weeks to spend the funds that were received. There was a cap on how much of the loan you did receive you could use for non-payroll things, which generally meant lease payments, utility payments, and some interest on long-term loans secured by real property. And another requirement was a reduction in the forgiveness amount if you did not rehire employees that had been terminated as a result of shutdowns or COVID and that sort of thing. As soon as the rule got issued, then banks started processing the loans. First loans were funded in the beginning of April. Later on in April, Congress passed an additional funding bill that basically refilled the pot. There was another, I believe, $300 billion that was thrown in for additional loans. And then just recently, Congress passed another statute. The President signed into law, I believe, this past weekend, known as the PPP Flexibility Act. That Flexibility Act largely addressed a lot of the forgiveness requirements that people were starting to wonder about. So the Flexibility Act was passed the beginning of June. Like I said, last week. It changed a lot of those rules that had been included in the SBA rulemaking process. So for instance, instead of a 2-year term for the loan, now the loans will be issued on 5-year terms. That change does not apply to loans that had already been made by the time the statute had passed, but it also doesn't require that the existing loans stay at 2 years. So if you've got a loan that you are going to be required to return or to repay, you may be able to still go to the lender and negotiate with them a 5-year term rather than a 2-year term. But any new loans that come out are being issued on a 5-year term. The original act or the original rule from the SBA had a time period in which you had to use the funds that you received. So your loan amount was based on 2.5 months worth of payroll costs, but you only had 8 weeks from the time that you received the funds to get them used and spent. There was a lot of concern especially with businesses that got the loans but weren't able to fully reopen yet because of state closing laws and guidance from the state governors. So that 8 weeks became a problem. So in the Flexibility Act, they expanded that time frame to 24 weeks or the end of December, whichever comes first, depending on when you get the loan. So rather than 2 months to spend the 2.5 months worth of funds, a business now has basically 6 months or so to spend it. The time period under the original rule to rehire employees, those employees needed to be either rehired or a new employee hired in their place by the end of June 30th. That's now been extended to December 31st. Again, that's to help address some of the small businesses that just couldn't open and get back to their previous levels. So for instance, a restaurant or a bar that could open, but because of the social distancing requirements, they couldn't have as many customers in there. Also helps address employees who really didn't want to come back to work because of the unemployment benefits that they were getting. By extending that time period, it allows the employer to rehire those employees after the unemployment benefit boost expires. It also, on the rehiring of employees, the amount of your forgiveness was going to be reduced if you didn't essentially restore your workforce, whether that was through restoring the number of employees or restoring the payments to those employees, payroll payments to those employees to the previous levels. There's some exceptions to that reduction. Now, if a business was unable to rehire employees because they were still closed, then that would accept you from that requirement. Additionally, if your business was unable to return to the same level of business due to health guidelines and restrictions from your area, then that also could potentially accept you from that requirement to bring back employees prior to the forgiveness being granted. As I mentioned before, the SBA's original rule had a cap on how much of the PPP proceeds could be used for non-payroll things, and it was a 25% cap. So if you use more than 25% of the funds for like lease payments, building lease payments, equipment lease payments, then your forgiveness was reduced by whatever amount you exceeded that 25% cap. So let's say you had 30% of the funds were used for that, then your forgivable amount was reduced by 5%. Now they've changed that to a 40% cap, so you can use up to 40% on non-payroll items, which essentially means lease payments, utility payments, and then some interest payments. You can get up to 40%, but the Flexibility Act also changed that sort of slope of how much forgiveness you've got to what's now referred to as a cliff. So if you exceed that 40%, you will not get any forgiveness on the loans. Even if it's only 41% that you used, you lose the entire forgiveness based on that 1%. This was a fairly big backlash on that sort of slope versus cliff change. And there's several Congress people who have indicated finding a solution to that problem through either the rulemaking process from the SBA or through a subsequent act from Congress. And the Flexibility Act also clarified that payroll taxes that the business may owe can be extended. You can pay those taxes 50% in 2021 and another 50% in 2022 without any sort of penalties from the IRS. So those are sort of the big highlights of the Flexibility Act and what it clarified or extended for forgiveness terms. Because of the passage of that Flexibility Act, we'll now have to go through another round of rules from the SBA. The SBA was scrambling to get the forgiveness applications and packages put together because that time period was starting to hit for some businesses. Now we'll have to wait for updates to that application and process before you can really start applying for forgiveness. Whatever application for forgiveness you file, of course, you're going to have documents that are going to have to be provided to the lender to support the request for forgiveness. So if you used it for payroll, payroll reports, payroll tax filings that you had to file quarterly reports. Depending on the payroll company that you use, there are a lot of payroll companies like ADP that will allow you in that payroll system to print a report from their system of what payroll expenses were paid. So that sort of documentation. Bank records, of course, if you held the PPP loans in a separate account and were able to account for every transaction out of that account, and whether it was used for payroll expense, whether it was tied to rent expense, whatever, that sort of documentation. So that's going to be required no matter what the form is from the SBA. So I think now's the time to start pulling that together if you haven't already. The SBA, so prior to Congress passing the Flexibility Act, the SBA issued additional, I think it was called a final interim rule at the end of May, which was essentially the final version of what they had issued at the beginning of April. In that end of May rules, there were a couple of additional clarifications that the SBA made to some of the forgiveness requirements for businesses that have employees who receive tips. So restaurants, delivery people, that sort of thing. The tip income for those individuals will qualify as some of what can be forgiven under the loan. So even though the loan proceeds were not actually used to tip those employees for purposes of calculating how much payroll there was, the tip amount qualifies under that SBA rule from the end of May. Additionally, bonuses and hazard pay that are paid to employees can also be used in calculating the payroll expense, just so long as, remember, for every employee, that you have $100,000 a year cap. So if hazard and bonus pay would push that employee over that pro rata cap, then it shouldn't be used. One downside to the SBA rule for self-employed individuals, for all other employees, the retirement or health insurance contributions that the company pays will count as payroll expenses. For self-employed individuals, the SBA rule excludes those payments, retirement payments or health insurance contributions. The SBA is essentially relying on guidance from the IRS in how that income or expense is attributed on tax returns. And the IRS says that that income is net self-employment income, that those deductions come after that. And because the net self-employment income is calculated after all reductions for employee retirement and health insurance expenses are paid, that your self-employed owner's retirement and health insurance contributions don't qualify as employee expenses. And so the SBA has sort of followed that same guideline and said those don't qualify. In the case of a self-employed individual, it doesn't mean you're out of luck, because they've extended the time for the funds to be used. So the 8 weeks versus the 24 weeks, if some of those funds were being attributed to retirement and health insurance contributions, you've now got more time to just attribute them to regular income for that self-employed individual. The end of May rule also clarified a couple additional things regarding employees. So for employees who did not want to come back to work or who had reason not to come back to work, and I'll clarify what that means in just a second. So if the employer provided a written offer to the employee to come back to work, that offer was rejected, and the employer notified the State Department of Labor that the employee had a job to come back to that they had rejected, then that employee does not count for purposes of determining whether you had a reduction in your number of employees. Essentially, if you're doing the math, they're taken off the original number and left off the final number. To the same extent, employees that were fired for cause, terminated for cause, and not terminated because of COVID-related shutdowns, or employees who just voluntarily resigned, retired, whatever, those employees also do not count for purposes of calculating whether there were employee reductions. So that's some additional good clarification from the SBA on how we're calculating employees for purposes of, did you maintain your payroll? The last thing I'll discuss is sort of an open issue that's still out there, which is how the IRS is treating some of these loan proceeds. So the CARES Act and the SBA guidance has made it pretty clear that the loan income from the PPP loans, to the extent it's forgiven, does not count as net income for tax purposes for when you get to where you're doing your 2020 taxes. However, the IRS has said any expenses that were paid by the business that were paid with forgivable loan proceeds will similarly not qualify as deductions on those tax returns either. So if you received a $100,000 PPP loan and all of that loan was used for forgivable things, so you paid, let's say, $75,000 in payroll, $25,000 on lease payments, so those payments were made purely with PPP funds, then for purpose of the IRS, when you get to do your 2020 taxes, you will not be able to deduct $75,000 worth of your payroll costs and $25,000 worth of your lease costs, both of which are normally fully deductible on your tax returns. So that's an issue that as soon as the IRS issued that guidance, several members of Congress said that's not what we intended and proposed statutes to address that issue. It was addressed in what's been called the HEROES Act, which was the additional stimulus bill that was passed by the House but has not made it through the Senate. And whether the entire HEROES Act makes it through or not, my prediction is that Congress will address that issue somehow prior to the end of the year. There's at least one industry group, CPA group, that's challenging that IRS determination. And I mean, to the extent it fully stands moving forward, you could always claim the deduction if you include that loan income as income on the tax returns, which you can do. You don't have to. And those are both good questions for the business's accountant. I think you run the tax return both ways and see what the net result would be either way that you do it. Like I said, still some open issues, things that Congress could still potentially amend or address, but they've at least addressed and fixed a lot of the forgiveness requirements that were causing the most trouble to businesses that had received the loans. Well, thank you for joining. It'll probably take a few days, but at some point this will be posted on the firm's website as well. If you like the firm's Facebook page or LinkedIn page, we'll post announcements on there every time a new class is set to go. And so you'll be able to see the topics and the things coming up. So appreciate everybody joining today. Thank you. Have a wonderful weekend.